Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This podcast will be about 12 minutes long. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Idgowitz, and today's case is Glebow Realty versus Dietrich, a fairly recent appellate term First Department case. First, let's set the stage with some context. Residential tenants in New York City have a lot of rights compared with tenants in other parts of the country and compared even with commercial tenants here in New York City. Commercial tenants in New York City have far fewer rights than residential tenants. Commercial leases and commercial landlord-tenant relationships are treated like regular business relationships between sophisticated parties. So typically, whatever is agreed to be in a commercial lease is what a tenant is held to in court. Commercial tenants don't have, for example, extra rights outside of the lease like residential tenants do, for example, with the warranty of habitability. But what makes a tenancy commercial as opposed to residential? What happens when you're living in a space and the landlord knows you're living in the space, but your lease is for a store or for an office, and your lease says at the top commercial lease or store lease or office lease? Does that mean that you're a commercial tenant and you have way less rights than if your lease properly acknowledged that you're a residential tenant? Well, that's the question in today's case. Now let's get into today's case. Now let's get into today's case. In today's case, the landlord brought a commercial holdover case, an eviction case for a store, against a tenant in the commercial part of the civil court of the city of New York. The tenant was using the premises for clothing design and making couture clothing. The lower court found, however, that the evidence at trial established that tenant also lived in the premises since 2016, that the premises were furnished with a dining table, bed, and television, that the landlord installed a shower, stove, and refrigerator, and that the tenant installed a sink and countertop with the landlord's knowledge and consent. The landlord was in the premises on about 30 occasions dealing with leaks. Therefore, the trial court determined that the landlord knew that the tenant was living there in the store. So the court dismissed the case. The landlord appealed, and the appellate court upheld the dismissal of the case by the lower court, holding that the rule from earlier appellate case law is, now I'm going to read, you guys know I always get to read one sentence on the Tenant Law podcast because, guys, remember, the law is words. So this was the basis of the court's decision. Despite the commercial nature of the lease, the finding that landlord knew of or acquiesced in tenant's residential use of the storefront premises has sufficient support in the record, and accordingly, the petition was properly dismissed. That's what the appellate case law tells us. You can't bring a residential case in the commercial part of the court. Now, this leads to some important tenant takeaways. First, let's get the housekeeping out of the way. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions to answer on the pod, not as legal advice, just to answer your question as general information on the podcast. If you like our work, please give us 5 stars and put this podcast on your socials. It's time for the tenant takeaway. Tenant takeaway time. Let's say you have a store or an office or a workshop and your lease says that the premises is for commercial purposes only, and you're having trouble paying your apartment rent, so you move into your store or office workshop. The existence of the use restriction clause in the lease is certainly a factor that will be considered by a court in determining these issues, but the court will also always look at 2 other things that they'll probably give priority to. One is your actual use. Are you actually living there, and can you prove that you're living there? And number two is whether the landlord knew about and or acquiesced in the actual use. As in today's case, the landlord helped convert the unit into a residence, and the landlord's representative was in the apartment about 30 times dealing with leaks and could see that it was actually an apartment. So, what you need to do if you find yourself in this situation is create as much of a record as you can as you go along, showing that the landlord cooperated with you in allowing you to live in the space or knew that you were there. The landlord can't simply feign ignorance. So let's say the landlord sends a plumber to fix your shower or a repairman to fix your stove. Send and save a text, email, letter, whatever you use to communicate, saying something like, I really need my shower fixed. I cannot go out in the morning without taking a hot shower. Or thank you for fixing my stove. I almost never order in. I like to make my own dinners. Please understand, I'm not suggesting that it is a great housing solution to live in your shop. What I'm saying is that this is New York City and it's filled with creators, and a lot of people do it. I've encountered people living in their shops a lot. And when I did the research for this podcast, I was surprised at how many recent published cases there are on the topic, which means it's happening a lot, which probably shouldn't be surprising in this very tight housing market. What I'm saying is simply what I'm saying. There's a strong legislative policy that all summary proceedings, all eviction cases to recover a residential premises should be commenced in the housing parts of the courts where a residential tenant's rights will be protected. And you should know that you can thwart an eviction case brought in a commercial part of the court on this basis. But you know what? Let's go a little deeper. Let's go a little deeper. Here's a new segment on the Tenant Law podcast called Let's Go a Little Deeper. Let's see how this goes. This is a bad market for commercial space in New York City as I record this. Landlords do not want vacancy from commercial tenants who are paying the rent because they might not get another commercial tenant who's going to pay the rent or as much rent. Landlords are not looking for vacancy. So if the landlord is coming after you in a commercial space that you happen to live in, it might be for one of two or three scenarios. We're going to look at two of them. First, they're probably just suing you for non-payment of rent. You might just not be paying the rent. And it really is for you who that advice I gave in the tenant takeaway is for. You're putting the brakes on the eviction process. The landlord is suing you for non-payment of commercial rent in the commercial part, but it's your home. It's where you live. So you tell the court that, hey, I'm living here. This is a residential situation, and the court will most likely dismiss the case. Now, that doesn't mean that the landlord is not going to go back and sue you the next day in the housing part. And that doesn't mean that it creates any particular defense for you in the housing part. I'm not saying it doesn't. That's beyond the scope of today's pod. But the point is that if you're not paying the rent and you're not paying for housing rent anywhere, and your business isn't throwing off enough to pay the rent in the store, you probably have bigger problems. Something isn't working in your life and in your business, and you have to reevaluate. So you're particularly the person who wants to slow down the eviction process and regroup. However, there might be another reason that the landlord comes after a tenant who lives in their store, and that's because the tenant lives in the store. If the landlord is bringing a case, a holdover case, specifically against the tenant because the use clause of the commercial lease says this is for business purposes only and the tenant is living there, if the landlord is doing that, it's likely because your neighbors are complaining. Either the residential tenants of the building or the other commercial tenants. Maybe when the kitchen was installed, it was installed incorrectly and there's an exhaust problem. Maybe there's noise. Maybe the look of the residence on the street level isn't working for the other commercial tenants. Something's going on if you're paying the rent and they're coming after you for this reason, it's because you're causing some type of a problem as far as the landlord and the other tenants are concerned. Now, if you're paying the rent and your business is successful there and you like being there and you have time on the lease and the location is important to you and you don't want to go look for another space, you might need to consider not living in your store anymore, because I don't want to suggest that that's not a violation of your commercial lease. What remains true is that case cannot be brought against you in the commercial part, because once you live there, whatever happens, it's got to be brought in the housing court because it's a residential situation. I was in court the other day and I heard this lawyer in this very situation. The landlord's lawyer was saying, but they're not supposed to live there, Your Honor. They're not supposed to live there. The lease says they're not supposed to live there, but they're living there. And the judge kept saying, yeah, that maybe they're not supposed to live there, but they do live there. You're sitting here telling me, counsel, that they live there. And if they live there, that means you need to be in housing court. And the lawyer just couldn't get his mind around it. And then I saw this case and I said, let me do a podcast on this case. So I don't want to leave you with the impression that it's an ultimate overall defense for all time against eviction that you live in your store. I'm not saying that's a defense to protecting your commercial lease, if that's what your priority is. So let's circle back and reiterate the tenant takeaway, which is simply this. If you're living in your store or your shop and you begin to have landlord-tenant problems, at the very least, you should understand that you cannot be sued in a commercial court for what is essentially a residential housing matter. That case can only be brought in a housing part where your rights as a residential New York City tenant can be properly protected. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.